Good afternoon, ladies and gentlemen. Thank you so much for joining us today for the webinar on New York Convention's journey of 62 years. The webinar is jointly organized by ICCA, UNCCI, and MCIA with Live Law as our media partners. The world at the moment is unfortunately reeling under a crisis like one never faced before. However, I cannot stress enough that it is institutions such as the ICCA, MCIA, and UNCCI, and many others alike, who must continue pushing forward their stated agendas without getting bogged down. Since our inception in 2016, the MCIA has focused on building an ecosystem for arbitration in India. A key part of playing the role of a catalyst for this ecosystem is enabling greater access to knowledge. Through this webinar, we hope to bring you views from stalwarts in the field of international commercial arbitration and what can be more important than the New York Convention itself. New York Convention is undoubtedly the most successful instrument in the realm of international trade law. Its success can be illustrated not only with the number of countries which have adopted it, to date being 164, but also with the exponential increase of world trade after its adoption. As Lord Mustill has expressed, and I'm going to quote, the New York Convention perhaps could lay claim to be the most efficient instance of international legislation in the entire history of commercial law. Simply stating, the convention incorporated two radical principles which, at that time, revolutionized the resolution of disputes with international elements, namely enforcement of arbitration agreements and enforcement of foreign arbitral awards. The convention prescribes a minimum legal framework, but it permits national courts to enforce arbitral awards under higher standards than those included in the convention itself. Though there has been an enormous influence of the convention on the arbitration world, and the influence continues to grow, would it be sufficient to say that a convention envisaged and drafted 62 years ago can continue in its current form to deal with legal issues arising in the modern arbitration world? There have been some concerns raised about the convention being too short, incomplete, or uncertain for modern arbitration, and consequently, it is important to address that time for reform has come. Some of these concerns was raised by a team of scholars led by none other than Professor Albert Vandenberg in 2008 at the occasion of the 50th anniversary of the New York Convention. And today we have Professor Vandenberg with us on the panel discussion, and we hope to have some lively discussions around these concerns. Questions of international comity, the role of the courts, and public policy under Article 5.1 of the New York Convention are still relevant after 62 years of the inception of the New York Convention. The issue of enforcing an award that was set aside, the problems and issues and different interpretation to public policy by different national courts revives the debate about the need to reform the convention. With this background, we bring to you today's webinar, The Role and Relevance of the New York Convention, a long 62-year journey. Today, we have with us Mr. Fali Nariman, a jurist who needs no introduction, senior advocate at Supreme Court of India, honorary president of ICCA, and successfully championing the cause of international commercial arbitration in India and outside. He will be delivering the introductory remarks, followed by which we will have a panel discussion with panelist Professor Vandenberg, partner Niuscha and Vandenberg at Brussels, and honorary president of ICCA, Ms. Bassiri, partner Niuscha and Vandenberg, again at Brussels, Mr. Gourab Banerji, senior advocate, Supreme Court of India, and vice chairman of UNCCI. The panel shall be moderated by Nair, advocate and arbitrator, Arista Chambers, and George Pothan, advocate, Supreme Court of India. On behalf of the MCIA, ICCA, UNCCI, and all the participants joining us today, I welcome our panelists. We have had a large number of participants expressing their interest to be joining this all-important webinar including international and domestic experts in the field of arbitration, retired Supreme Court judges and High Court judges, amongst others. I wish the panelists all the success, and I am sure that there are going to be lively discussions with it. I request the participants to kindly ask all their questions in the Q&A section of the Zoom, and the panelists and the moderators will pick those questions as we move forward. With these opening remarks, I now hand over the reins of the webinar to Pramod and George. Thank you.
Thank you, Neeti. Thank you for a wonderful introduction. Good morning, good afternoon, good evening to an audience from around the world. At this point in time, we are here to discuss the role and relevance of the New York Convention after a 62-year-old journey. As Neeti just put it, this is one of the most successful UN conventions with over 160 signatories, 164 as on date. And to begin with, as Mr. Fali Nariman puts it, New York Convention is an indispensable element in the structure of international commercial arbitration. Add to that, I would call the New York Convention as the backbone of international arbitration, as without it, it would render international arbitration futile and toothless. As otherwise, the enforcement of arbitral awards in itself would be a challenge in itself. Not that it's a rosy ride now, but we are here to overcome those challenges and find solutions. In India, the New York Convention is implemented through Part 2 of the Arbitration Conciliation Act of 1996. And it's time to reflect if India has truly delivered on its obligations under the New York Conventions over the last 6 decades. The Indian jurisprudence has been ever evolving, and recent judgments have mostly added to the positive approach towards it, with maybe a few hiccups here and there. However, there is a need to bring the Indian practice in consonance with the obligations under New York Convention. And again, I quote Mr. Nariman on it, how he puts it. The best way to do it, that is to bring the Indian jurisprudence in consonance with the international jurisprudence, the best way to do it is to benefit from case law from the best way to do it is to benefit from case law from courts around the world. International arbitration continues to be the preferred method of dispute settlement despite the pitfalls. And as lawyers, we should not stop learning and find solutions, find ways out of it. And who better to learn it from Mr. Nariman? I've had numerous occasions to interact with him, be it in court, the corridors of the court, at conferences, over a cup of tea or meat. And with each interaction with him, there's something new I've always learned. Dear arbitration practitioners, students, lawyers, judges, and anyone with a keen interest on arbitration, Mr. Nariman's latest book, the Arbitration series, which comes in 2 volumes, here for all of you to see. These are 2 books, the Harmony Amidst Disharmony. The volume 1 is the Indian framework, and the second volume is the international framework. For anyone who wants to learn more, who wants to learn from the experience of someone who's seen it all, the entire 62-year-old journey, please have a look at these books. Thank you. And I now hand it over to Mr. Nariman for his remarks.
Good afternoon, or good evening, or good morning to you all, particularly fellow students. We are all fellow students, whether you are a judge or an advocate or a teacher or a professor. We are all, for the rest of our lives, we are students of law. And therefore, it's a pleasure to address particularly the student faculty at the Bangalore Law School, and also the student faculty, whoever are listening in. The function of the New York Convention is to make arbitral awards in international commercial arbitration readily transportable, that is, enforceable in every convention state. And this process, as you all know, has been greatly facilitated by the UNCC model law of 1985, which had been rightly described as a masterpiece of constructive compromise. Do remember that enforcement of arbitral awards, not refusal to enforce them, is the sole justification of all international commercial arbitration. And the role of the New York Convention is directed to this end. For years, there were two principles that had been constantly affirmed by the courts and implicitly confirmed by the Convention. And the first principle was, oh God. The first principle was that the court of the country in which or under the law of which the award was made was the court exclusively competent to decide an action for setting it aside. Mark the words, exclusively competent. And the second principle was that the setting aside of an award had necessary extraterritorial effect, since it precluded enforcement in other contracting states by virtue of ground E of Article 5(1), which is the equivalent of our Section 48 of our 1996 Act. These assumptions were never questioned before the 1990s, but somehow in 1996 and 1997, there was a trilogy of cases, names of which are unnecessary, but it's the Choromalai Aero Services and Arab Republic of Egypt and the OTV Hill-Martin decisions of the Swiss court, the French court, and the Egyptian courts. And the importance of this somewhat confusing litany of cases, which ends, of course, with the latest UCOS case, which is still before the Supreme Court of the Netherlands. The importance of this confusing litany of cases is they have in separate ways brought into prominence a congenital defect in the New York Convention, namely absence of any international standard for annulling arbitral awards. But such a standard is alien to the convention as it is structured. The New York Convention was and still is limited to the recognition and enforcement of foreign arbitral awards. It did not and could not apply in the country in which or under the law of which the award was made. That's the country of origin. The setting aside of foreign arbitral awards was therefore left exclusively, again mark the word exclusively, to the law of the country of origin, the place of the award. Such law could conceivably include, and at one time in the case of many contracting states, did include, grounds for setting aside which were not limited to the grounds set out in Article 5, enabling courts to refuse recognition and enforcement. This is precisely what happened in that trilogy of cases that I was just mentioning, the Choromalai and Hill-Martin. The award had been set aside, or the awards had been set aside in the countries of origin, Egypt in one case, Switzerland in the other, for peculiar reasons contained in their respective domestic laws, not on any of the grounds mentioned in Article 5 of the Convention. This is perhaps the only true rationale or basis for the conclusion reached in the first three cases that I mentioned. But it would be more correct to say that the concept of an international award, international in inverted commas, an award without territorial nexus, has now arisen phoenix-like from the ashes of the setting aside decisions in Egypt, Switzerland, and much more recently in the Netherlands. Interesting questions that we will all keep debating until the publication of the second edition, long overdue by 40 years, of Vandenberg's masterly treatise on the New York Convention, of which this is the first edition. It is titled Towards a Uniform Judicial Interpretation. There probably will never be a universally uniform judicial interpretation. It appears to me that Clause E of Article 5, which is reflected in our Arbitration Act Section 48(1)(e), does have a purpose. And its purpose is, and let me state this as a purposive construction of this article, which has created much debate and confusion. The purpose is to declare that ordinarily and almost always, but not necessarily always, when an award has been set aside by the court of exclusive competence in the country of origin, it may not and should not be recognized or enforced in other contracting states. But exceptionally means rarely, it may be so recognized and enforced in other contracting states where either of two conditions are satisfied. First, that the reason for its annulment is on grounds different from those set out in Article 5. Or, secondly, where the domestic law of the contracting state is more favorable to enforcement than the provisions of Article 5 of the Convention. Any further residual discretion, in my humble view, cannot be spelt out by the deliberate use of the word may, with which the entire Article 5 begins. The following example would show you why. It is an example reflecting actual current practice. Take the case of a New York Convention state, which has also adopted the model law. Most New York Convention states have adopted the model law and have incorporated into their domestic legislation provisions for setting aside awards analogous to Article 34 of the model law. The grounds in Article 34 for setting aside are identical with the grounds set out in Article 5 of the New York Convention for refusing enforcement, thus eliminating the possibility of invoking Article 7, which is the article which states that the New York Convention shall not affect the validity of multilateral and bilateral agreements concerning the recognition and enforcement of arbitral awards entered into by contracting states. In such cases, it is submitted that where the award has been set aside in the court of the country of origin on one of the internationally accepted grounds, courts in other contracting states may not, cannot, and ought not to ignore the ultimate decision relying on that catch-all permissive word may in Article 5. And there is a purpose to this. In my view, this is because the convention has been drafted on the premise of the losing party being afforded the right to have the validity of the award finally adjudicated in any one jurisdiction. Emphasis on one jurisdiction. That is to save that losing party being pursued by a claimant with an unending series of enforcement actions from country to country until, God willing, there is some court somewhere that ultimately grants enforcement. That's all for the moment. More in the discussion that follows.
Thank you very much, Fali. That was probably as comprehensive an introduction as could be managed within 15 minutes. We're very grateful to you for setting the tone for the discussion. So what we are going to do is to try and break down some of the points that you made into questions that we will be posing to the wonderful cast of panelists that we have today. If I could just start off the first question. just taking a step back in terms of why the New York Convention was entered into in the first place to replace the Geneva Convention of 1923, which really hadn't, in that sense, run its course fully. It was, in a sense, replaced very quickly with the New York Convention. Professor Vandenberg, could I request you to provide an overview of the New York Convention and the reason as to why it was felt necessary for a new convention to replace the Geneva Convention or the Geneva Protocol of 1923? Professor Vandenberg, I think you're on mute. You may have to unmute yourself.
Can you hear me now?
Yes, perfect. Thank you.
Okay, thank you. Let me first express my greatest pleasure and privilege and honor that I can share here a webinar with my good old friend for more than 40 years of Fali Nariman. I really have the greatest respect for him as one of the greatest lawyers of our time in the field of arbitration. I understand also in other fields. Fali, most welcome to see you again. Having said that, Fali, you will not be disappointed about me that I do not entirely agree with you what you just said about the residual discretionary power of judges on the New York Convention. I have a different view. I think that under the New York Convention, you cannot refuse enforcement of an award that has been annulled in the country of origin. But that is not the answer I'm going to give to the question that's asked to me. The question being asked to me is, what was the history of the New York Convention? Now, may I refer the webinar participants to my website, which is simply called www.newyorkconvention.org, and where you find under the tab Travaux Préparatoires, the legislative history of the convention. In short, it was this. Almost 1 century ago, in 1923, 1927, there were established 2 treaties. One called the Geneva Protocol on the validity of arbitration clauses, and the other one, a few years later, the Geneva Convention on the execution of foreign arbitral awards. They, in practice, because of the environment at that time, the legal environment of hostile arbitration laws and hostile judges, it did not work satisfactorily. And basically, it hindered the smooth functioning of international arbitration in practice. After the Second World War, then, in 1951, there was a conference in Lisbon of the International Chamber of Commerce. And for the reminders for the younger viewers amongst yourselves, the ICC court was established in the 1920s, and that operated on the basis of the then arbitration rules of the ICC court. The ICC court at that time was concerned that it didn't function well because of the hostile arbitration laws and judges to arbitration. So they adopted in 1951 a resolution that this situation should be changed, and especially should be changed by having a revised treaty of the Geneva treaties. Geneva treaties were considered to actually mirror what went badly in the national local laws on the ICC arbitration, and therefore they said we need to improve this. So basically the ICC then says we want a new convention. And true to their words, in 1953, they published a preliminary draft convention. And the reason behind that, if you read that convention, then you will see that it's really a concept avant la lettre, in that it contemplates a national arbitration. Arbitration detached of any interference of national arbitration law. That reason was not such a brilliant conceptual principle, as rather that the ICC didn't want to be hindered in its ICC arbitrations by local arbitration laws. It was then picked up in 1954 by the Economic and Social Council in Europe, and they established a committee on the enforcement of foreign arbitral awards. In 1955, they came out with a report, that committee, and the proposals by the ICC of an national arbitration was too daring for them, and they went back simply to what has been always been the case, that an arbitration, at least commercial arbitration, is governed by the arbitration law of the place of arbitration. That then evolved in the idea of adopting indeed a revised convention. And after many comments and meetings, in 1958, of 20 May to 10th of June, a conference took place in New York. That conference was in the first week basically a Tower of Babel. Nobody could agree on anything. And here it is where, what also mentioned by Fali Nariman, where Peter Sanders enters the scene. He, in the weekend, went to his father-in-law on Long Island, and in the garden, in the back garden, with an Olivetti typewriter on his knees, he drafted a new convention, a new text. He returned on Sunday evening to New York, and there he organized his friends from a number of countries to support this draft. And they indeed supported the draft. And what was so important about this draft? It was important that a clear distinction was made between the conditions to be fulfilled by the petitioner, what the petitioner has to do in order to obtain enforcement of an award under the convention, and the grounds for refusal of enforcement that has to be proven by a respondent. You see that clearly separated in Article 4 and Article 5 of the present convention. And basically that became the convention. Now, there is also an article which you find in Article 2, which concerns the arbitration agreement. That is a very last minute insertion, because at the end of the conference of the second week, the idea prevailed that we should have also provisions on the arbitration agreement, because at the commencement of the arbitration, and then that was drafted almost in haste and inserted in the convention. It shows, because especially Article 2 has a number of holes in it. One final point is the convention is known that it would have abolished the double exequatur. The double exequatur is on leave for enforcement both in the country where the award was made and in the country where the award is sought. That is indeed an improvement that has been abolished under the New York Convention by replacing the word final in the Geneva Convention by the word binding in the New York Convention, Article 5(1)(e). But in my view, it is not the most important one, improvement. The real improvement was that you made the convention makes clear who has to do what, the petitioner and the respondent. From what I think that hopefully gives in a bird's eye view the history of the convention.
Thank you so much, Professor van den Berg. And I think it is wonderful that you provided all of us with the key role played by Peter Sanders in formulating the convention as it stands now. In fact, at the 60th anniversary of the New York Convention a couple of years back, I think you were the one who actually proposed that he should be awarded the Nobel Peace Prize for his wonderful work in this area.
I think so, but one thing is, if I may mention for the viewers, if you really would like to see what happened in New York, watch the video we made of him, with his memories of the New York conference of 1958, including that he lost his shoes in the hotel, so which you find on the ICCA website. So if you go to the ICCA website, you see then historic treasures, and there you find the video where he was interviewed and tells us, shares with us his memories.
Thank you, Professor van den Berg. I think what a wonderful history. And the convention, of course, has grown from strength to strength. I think after the UN Charter, it has probably the highest number of ratifications, and the number seems to be growing year after year. I think earlier this year, Ethiopia became the 163rd state to ratify the convention. You made a very interesting point about a last-minute insertion to the New York Convention. So maybe we can start the discussion from there. The midnight clause, as it were, of the New York Convention was Article 2. Gourab, could I ask you your question in respect of the enforcement of arbitration agreements? I think very often we forget that there are two main aspects of the New York Convention. One is the enforcement of arbitration awards, but there is also a very equally important aspect of enforcement of arbitration agreements. And the phrase that is used is that national courts are obliged, as a matter of the New York Convention, to enforce arbitration agreements. And the exception is that unless the arbitration agreement is found to be null and void, inoperative, or incapable of being performed. Could you explain, for instance, what has been the Indian experience with interpreting this phrase, and what is the standard of proof that needs to be established? Is it a matter that has to be established on a prima facie basis, or does it have to be conclusively proved that an arbitration agreement is null and void to persuade a national court not to refer the parties to arbitration?
Thank you, Pramod. Before I answer your question, I must admit that this is a fanboy moment for me, because I'm on the same panel as two of my absolute idols, Mr. Nariman, who I've known since school, and Professor Vandenberg, before whom I appeared as a junior counsel in 1998. So thank you, MCIA and ICCA, for giving me this opportunity. Now to come to your question, on Article 2.3, as Professor Vandenberg mentioned, this came in right at the end. And the New York Convention doesn't even mention in its title that it has anything to do with arbitration agreements. It says Convention for the Recognition and Enforcement of Arbitral Awards. So obviously this is a last-minute addition. And as Professor Vandenberg correctly says, there are problems with the language. And I'm not going to address that bit. But from what I understand of your question, the question that you wanted some feedback on is what is the Indian experience in regard to the burden of, rather to the standard of proof? Should it be on a prima facie basis, or should it be on a sort of conclusive basis, on a final basis? The idea being, if you go to a court and if you're sitting as a judge, and this case comes before you, and there's an arbitration clause, should you then compulsively refer it to arbitration or not, or should you take a prima facie view? That's the question. And interestingly, India has had an interesting response to that. The first response was a judgment called Shinetsu, which is a 2005 judgment. Sorry, before that, if you look at the article itself, Article 2.3, it does not give you any guidance as to the standard of proof, whether it's to be prima facie or whether it is to be conclusive and binding. The Travaux also does not give you any guidance. There is some discussion on this aspect in the model law aspect, because we are looking at the convention, which is the enforcement stage, but there is a mirror image which is there in Article 8 of the model law, which is similar for domestic. What we have is our Section 8, which is the Article 8 model law, which has similar grounds for staying arbitration proceedings. So there's some mirror. I'll come back to that. But the Indian experience, this provision, Article 2.3, is reflected in Section 45, and Section 45 basically was a copy, cut and paste of Article 2.3. And this matter fell for decision, as I mentioned to you, in Shinetsu. And Shinetsu is a weird judgment, with the deepest respect to the Supreme Court, because there are three judgments. One judgment, the first judgment reported, is of Justice Sabharwal, where he takes the view that this is an issue which should be decided finally, in a final, conclusive manner. But that was the dissenting view. Then there is the second judgment of Justice Sri Krishna. Justice Sri Krishna takes the view that no, this is not the way to go. We should have a more pro-arbitration outlook. We should decide questions on whether it's null and void, inoperative, on the basis of a prima facie. So that's his view. Both the judges take into account the French, the Swiss, the German, various commentaries, and come to diametrically opposite decisions. Then you have a concurring judgment of Justice Dharmadhikari, who says, by the way, I agree with Justice Sri Krishna that it should be a prima facie view, but if you think that you will not refer it to arbitration, then with the rider, now you should have a full trial. So you have a third view, absolute, utter and total confusion. And fortunately, this has now been sorted out. The first step was that in 2015, Section 8 was amended and the words prima facie were introduced in Part 1. But in 2019, pursuant to the high-powered committee report, the phrase prima facie has now been introduced to really solve the problem. So as far as India goes, we have adopted the prima facie test. But as you will realize, Pramod, both have their pluses and minuses. One is pro-arbitration. One is the absolute approach, the finality approach is something which can be justified on the basis that the court will not be looking at the matter again and wants to sort of conclude the matter because it will go off to some different court and there will be a different examination. So there is some plus point to finality. And I believe, and every country takes a different view. So France and India seem to take the prima facie view. I believe the US does. I understand that Germany, Austria and Switzerland take a different view. So there's no one right answer, and we've picked the answer of prima facie. So far as null and void, inoperative and incapable of being performed, that will require possibly another seminar, so I'm not going into it. They are vague as vague can be, and as Professor Vandenberg has pointed out, there are many, many loopholes in those phrases.
Thank you, Gourab. I think a very important point that you made was that the New York Convention is something which provides a bit of a fertile landscape for transjudicial borrowing. The text is the same, so the tools are the same, and countries therefore rely quite frequently on the jurisprudence evolved by other countries in determining issues that are raised before their courts. So Niuscha, if I could invite you to come in with your thoughts and provide us from a comparative perspective what the approach in other jurisdictions has been on this point.
Thank you very much. And I also have to first thank you, Pramod and George, for inviting me, UNCCI and MCIA, to this fantastic webinar, because it is a big honor and pleasure. And I'm a little bit intimidated, I have to be honest, sitting with Fali Nariman and Avadian on this New York Convention topic together on a panel. But I will do my best to learn, as Fali rightly said. So I have two home jurisdictions. One is the German and one is the Belgian. My main home jurisdiction is the German jurisdiction. That's where I studied law, that's where I applied law, that's where I did my training. And so I will focus on that one. And indeed, there is section 1032 of the Zivilgesetzbuch of the Civil Procedure Code, which I would like to read out because it does take another route, as Gourab just said. The English translation is as follows. So 1032.1 provides: a court before which an action is brought in a matter which is the subject of an arbitration agreement shall, if the respondent raises an objection prior to the beginning of the oral hearing on the substance of the dispute, reject the action as inadmissible unless the court finds that the arbitration agreement is null and void, inoperative, or incapable of being performed. And paragraph 2 provides: prior to the constitution of the arbitral tribunal, an application may be made to the court to determine whether or not arbitration is admissible. So while there is some resonance in the wording at the end of 1032.1 with respect to unless the court finds that the arbitration agreement is null and void, inoperative, or incapable of being performed, there is also another nuance in the German perspective, and that is this wording of inadmissible. So if a claimant brings to the court an action, and the respondent invokes the arbitration agreement, then the court may consider that action of the claimant as inadmissible unless the arbitration agreement is null and void, inoperative, and incapable of being performed. That is a reform from not now already a long time ago, 1998, which actually turns around what had been the case before that under German law. Under German law, the competence, German words, actually was given as a final review by the tribunal under the old law. This has been reversed because, as the travaux of the 1998 law provides, the legislator wanted to have an early decision on the jurisdiction issues. And hence, this very early possibility for the court to actually go into a full comprehensive review. And the second paragraph of 1032 even accelerates that earliness, because even before a tribunal has been constituted, an applicant may actually go to the court and ask for a declaratory relief that the arbitration is not admissible or is admissible. So when I talk about admissible, that's the word that is used in the provision, and that's a deviation from the New York Convention, where it says refer to arbitration. And one of the reasons is because, being German pragmatic, because the court said, well, maybe there is no arbitration yet pending, so to which arbitration shall we refer it? But that as aside, so this early dismissal basically has been put into the code precisely in order to have early on, before time and cost is wasted by the arbitration proceedings, already a decision by the court. But there are requirements as well. So in 1032.1, that is when the claimant brings a case to the court and the respondent objects with the arbitration defense, there has to be actually a couple of requirements. And the last one, which is resonating from the New York Convention, unless the arbitration agreement is null and void, inoperable, or incapable, is again also interpreted differently by the Supreme Court in Germany. And I think that's quite interesting, because 20 years back, there were a series of decisions by the Bundesgerichtshof, which actually also considered that there is bad faith of a respondent in a court proceeding invoking the arbitration defense if that same respondent is actually hindering the arbitration by not paying its share for the arbitration fees. So the funding issue might, I think, have subsided now, because now you have third-party funders, etc., that back at the beginning of the millennium weren't so active at the time. But it's still important to note that there is this limitation as well in terms of when actually a respondent can bring this objection and the arbitration defense. So good faith plays a big role under the German law as well.
Thank you, Niuscha. Another issue that has cropped up and has created a fair bit of controversy in the Indian context, but I also understand in other jurisdictions, is when does an arbitration actually become international, or when does an award become a foreign award? In terms of the questions which have been raised in India, if two Indian parties were to choose a foreign seat of arbitration, first of all, the question would be whether that would be a valid choice, whether that is a choice that would be enforced by the courts. And secondly, if, for instance, two Indian parties were to agree to resolve their disputes in Singapore, and Singapore is chosen as the seat of arbitration, whether the award that is rendered at the end of the process would be a foreign award that is capable of being enforced under the New York Convention. Gourab, do you have any views on both these questions?
This is obviously a burning issue now for many of us in India. And the reality is that my heart says one thing and my analysis seems to suggest another. So let me try and answer this. And I think it's a gray area. Obviously, it is a gray area because it's not been thrashed out, but let me try and answer it the best I can. So there are two parts to your question. so far as the, and I think they're interconnected, and particularly since we are speaking about the New York Convention, I'll focus more on the enforcement aspect. But as you know, this aspect of two Indian parties having a foreign seat has been litigated in India. I mean, we've had the Sasan Power Madhya Pradesh High Court series. We've had two judgments of the Bombay High Court going the other way, and which is Seven Islands and Aadhar Mercantile. And then we've got, I think the latest wisdom on this is a judgment of the Delhi High Court in GMR versus Doosan, which if you have a look at essentially sums up both sides. But essentially, I mean, the argument is this. On the one hand is party autonomy, which is why I say that my heart is in favor of party autonomy. That why should you prevent two Indian parties conducting an arbitration seated abroad? There really should not be any bar, apart from the fact that it may not be a great reflection on our internal system that two Indians are going to Singapore to arbitrate. But why should there be a bar? So what's the argument against it? The argument against it, which has been put up on the basis of some observations in TDM. TDM was a judgment under Section 11 by Justice Sinha. The argument seems to be that there is a section in Part 1 of the Act, which is the domestic part, which says that the governing law inter se two Indians has to be Indian law under Section 28. And his understanding of Section 28, which is Article 28 of the model law, tweaked, along with Section 26, is that you cannot contract out of this portion, and this is non-derogable. So on that basis, it is suggested that you really cannot, that you must have a domestic arbitration. I think that's a bit too far. But there are some issues, and therefore GMR goes to the extent of saying that TDM is not relevant. It's a Section 11 judgment. It has no precedential value. There is already a judgment called Atlas Exports of the Supreme Court, which said that you can have a foreign arbitration between two Indian parties. So that's the GMR view. But there is the view taken by Justice Indu Malhotra in her latest book, where she says that this is illegal. And that's what makes me a little worried, because this is not just any author, this is somebody who knows what she is talking about. But let me put it a little differently. Let me take your particular example and then let's run it through. So two Indian parties decide to go to Singapore, as they have, and conduct an Indian arbitration with the governing law as Indian law. Surely this cannot be a violation of Section 28, because 28 is in Part 1 and it also says the substantive law is Indian law. So that, according to me, does not raise stricto sensu a public policy argument, because now we're on the New York Convention. And the New York Convention defenses are very limited, as we all know. Is this Article 5.2 defense, 5.2b defense of public policy. So the question is twofold. Supposing the two parties adopt English law, two Indian parties go to Singapore and adopt English law, Singaporean law, would you then say that you have contracted out of the substantive law, particularly in the light of that one paragraph in TDM which he says it's non-derogable part of Indian public policy? More tricky question. Third possibility, which somebody brought to my notice a week ago, why should you, what is being contracted out of if you go out of India? If two Indian parties go to Singapore, what is being contracted out of? What has been put to me is that in India, it would not be an international commercial arbitration because it's two Indian parties. And you would have a right of challenge statutorily provided under 34(2)(a), which is patent illegality. If you have a foreign award between two Indians applying Indian law, you have, by the process of moving your arbitration out of India, contracted out of 34(2)(a). So that's one issue on the public policy defense. On the other aspect which you mentioned, you said whether there would be any problem under 2(1)(f, according to me, no. Because a foreign award under Part 2, which is Section 44, which is Article 2, a foreign award is not necessarily equated to an international, to a 2(1)(f situation. So you can have a foreign award between two Indian parties. In fact, there's a very recent judgment of in the Rajasthan High Court, which makes this distinction. So to sum up, what I will say is, yes, I feel that there should not be any problem in enforcing a foreign award of that sort, subject to two caveats. Caveat number one, if you have a foreign substantive law, you may run into difficulty. Caveat two, somebody may argue that 34(2)(a) has been excluded. Whether this is sufficient to trigger the high threshold of a public policy challenge remains to be tested. And last but not least, Justice Sindhu Malhotra is a sitting judge of the Supreme Court, and if she thinks that this is illegal, then I may have missed something. So I'm sorry I couldn't give you a black and white answer, but this is where we are. So far as foreign jurisdictions are concerned, Professor Vandenberg has brought to my attention a judgment of the Italian Court of Cassazione, which is their highest court, which is reported in the very first volume of the yearbook, and it's a judgment of 1971. I didn't realize, that such old judgments hold the field, where this point was put up between two Italians who said, well, under the Italian civil code, I can only litigate in Italy. That was shot down. But I don't know how far we can carry it here. So it's a word of caution to all those who are listening now and who are having arbitrations in Singapore. Beware, you might have problems enforcing them.
Thanks, Gourab. I think it's important to make a distinction, as you mentioned, between one, choice of law on one hand and choice of forum on the other. They are interrelated, but they are nevertheless distinct. The second aspect is when the judge in TDM mentioned that it would be contrary to Indian public policy for two Indian parties to contract out of the application of Indian law. There are probably two interpretations to it. One is, the broader interpretation is that it would include both substantive as well as procedural law. A narrower reading could be that two Indian parties cannot contract out of Indian substantive law, but if they nevertheless choose to arbitrate in Singapore, they would of course be subject to the supervisory jurisdiction of the courts in Singapore. The Indian courts would have residuary jurisdiction because the award would be, could be enforced in India, and the courts could then, in a sense, exercise passive review over that award. So the judicial safeguards still exist even in such a situation. But you're right, I mean, some of these issues will have to be thrashed out probably in due course in a case which may have to be decided by the Supreme Court all over again. Professor Vandenberg, if I could request you to guide us with your thoughts on this. Do you believe that in a situation like this, if two Indian parties were to choose an offshore seat, whether the resulting award would be a New York Convention award? And if it is, would that be consistent with the spirit and the underlying purpose of the New York Convention?
I think, thank you, Mohammed and Gourab. I think you have to distinguish between the two actions. If it is an action for the enforcement of the arbitration agreement under Article 2.3 of the Convention, then you may indeed question whether or not nationality of the parties is an issue. But if it comes to the arbitral award, enforcement of the award, which is the second action contemplated by the Convention, I think that the Italian Supreme Court got it right. Originally, in Italian courts had the same difficulties as I understand are now in certain Indian courts. They got it right that local law for prohibiting the own nationals to arbitrate in another country is not applicable to the New York Convention. The New York Convention is not limited to diversity of nationality. And that was unlike, for example, the Geneva Treaties, which I mentioned earlier. They had diversity of nationality requirement, but nationality is not a requirement under the New York Convention. So I would think that the two Indian parties arbitrating in Singapore, which is not only, that's not only a country where they do this, they arbitrate in another country, that is a valid agreement. Subject really to concepts like fraud to the law, etc. Because that's a different story. But in general, it should be allowed. That is the what Fali Nariman referred to, the portability of the award and the agreement.
Pramod, can I be permitted to ask a question of Professor Vandenberg?
Sure.
So the challenge is in this fashion. No doubt you can go to Singapore under Indian law, get an award. But when you come to enforce it in India, the defense which is being put up is that had you had this arbitration in India, the scope of challenge would have been much wider. And you as Indians have gone to a different country and you have avoided that wider scope of challenge of a domestic award. Is that a public policy defense?
But your question presumes that for the sole reasons of the wider review, of the narrower review, these parties go to Singapore to arbitrate. There may be a host of other reasons why they do this. So I would be rather reluctant to say, well, wait a moment, this enters now already in the realm of public policy. On top of that, public policy by courts in many countries now around the world, public policy on the New York Convention, is interpreted narrowly as referring to international public policy. So I don't think so that public policy comes in principle, but there may be depending on the circumstances.
I just wanted to add also, depending on the circumstances, I mean, Gourab, would it make a difference if there would be an international element to it? Because, for example, the subject matter of the underlying agreement is actually has something to do with Singapore, with another country than India. Would that make a difference in your view?
The way we have defined our law under 2(1)(f) is that for it to be an international commercial arbitration, one or other of the parties has to have some international flavor. I mean, that's how we've, it's a very narrow definition under 2(1)(f). So,
Rob, if I may add one case, you mentioned the Italian Corte di Cassazione of 1971. I was happy that my memory went back that I could remember the case, but there's a more recent case, IPCO, in the English courts. I think it is UK number 70, if my memory doesn't fail me. And that is a similar situation. That was a case between two Nigerian parties, dealt with under Nigerian law in Lagos arbitration. Everything was Nigerian in the case as far as the award is concerned. And the award came then to London for enforcement, and because for reasons that probably they could find assets of one of the losing party in London. And there the argument was raised, yeah, wait a moment, this is purely Nigerian, but you have to do your honors here in London with a purely Nigerian affair, because they should figure that out in Nigeria. And the courts were correct. It says, well, the New York Convention does not impose a nationality requirement, and therefore we enforce also this, what seems to be a purely domestic award in England, or United Kingdom, I should say.
So that should also help in saying that two Indian parties coming to enforce a Singapore award in India, merely because of their nationality, it should not militate against it being a New York Convention award. It is a New York Convention.
Nationality alone, no. But you have to, in the crafting of the applicable law, I still live under the knowledge of the Singer decision in India, but I know that has been repealed a number of years ago.
Singer's gone.
But nonetheless, what you should do if you do it as two Indian parties, I think you should be careful in stating in your arbitration clause that it is governed by Singapore arbitration law. arbitration itself, not the merits. So the merits may be a different story. Because to stay for certainty, I don't say this is essential, but I would be advisable to do it that way.
I think now the Indian courts are sophisticated enough to realize that the substantive law may be Indian law, but the law of the arbitration agreement may be different, the curial law may be different. So I can understand that. Pramod.
Could move on from there. We'll be talking about, as Mr. Nariman put it in his inaugural address, we are looking at universally uniform judicial interpretation. If that is possible across boundaries, that's a thing. We've heard on this panel by two of the authorities, they themselves have a difference of opinion on a particular topic, on a particular subject. And if I can put this to Mr. Gourab Banerji, the meaning of the word may under Article 5.1, how much discretion does it confer on domestic court to refuse recognition and enforcement? Should a test of actual prejudice be read into Article 5? Or should a party have to establish not only the existence of a ground for refusal of enforcement, but also prove that actual prejudice was caused to it as a result? Over to you.
Okay, so this, George, you've put me in the situation of this tiny fish between two sharks, Mr. Nariman on one side and Professor Vandenberg. But I'll try to address it in the way that
I think we need a third view when we've said. So when we had two diverse opinions, I think the third view would be there.
So let me put it in this fashion. The article which is relevant is Article 5.1. 5.1 is the, as you know, 5.1 is our 48.1, and 5.2 is the public policy defense. So 5.1 uses the word may. I mean, I'll just read it if you permit me.
Yes.
Recognition and enforcement of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the competent authority where recognition and enforcement is sought proof that ABCD, whatever the grounds are. So the question is, how do you understand this phrase may be refused? Now, there are at least three versions of this. One version is that this may be refused means that even if you find one of the grounds for refusal, you have a residual discretion not to refuse, i.e. to enforce the award. The pro-arbitration sort of spin on the New York Convention may be refused. Even if you find a ground for refusal, you may yet not refuse. That is one way of looking at it. One way of looking at it is the annulled award theory. May be refused means you can do whatever you want. You can refuse, you need not refuse, you have discretion, which is one view also. The third view was Professor Vandenberg's view was that this article, when properly read, does not give any discretion. You either fall within the 5 grounds of refusal or you don't, and that's the end of the matter. So obviously the third aspect Professor Vandenberg will explain. But so far as the first and the second aspect, the annulled award aspect is concerned, the Indian position is the first one which I mentioned, that may be refused means that even if one of the grounds are made out, those 4 or 5 classic grounds under 5.1a, jurisdiction, etc., jurisdiction, all the 5 grounds, even then you may decide as a court not to refuse enforcement. And the judgment in which this actually has been considered in some detail is a recent judgment which I'm sure most of you will be familiar with, which is the Vijay Karya Prismian judgment. Justice Rohinton Nariman's exposition of the law on this aspect. Where, I mean, just by way of background, and I'll just take 2 minutes on this. One of the arguments made was that even if one of the grounds is made out, you may still not refuse enforcement because of the pro-arbitration so pro-enforcement bias of the New York Convention. And this argument was accepted by a 3-judge bench of the court. And he gave a very interesting spin on it. I mean, he referred to various judgments like Dalla versus Pakistan. He referred to various textbooks. And he said, look, there are 3 categories of objections that can be taken under section 48, which is the same section, which is basically Article 5.1 and 5.2. And he said that there are 3 categories, and he analyzed the 3 categories. And he said the first category is where you are questioning the tribunal's jurisdiction. The second category is connected to the party, denial of natural justice and such. And the third category is public policy, which is basically, again, a matter for the court, whether it's arbitrability or substantive public policy. So in his view, in the first category, jurisdiction, there is no question of exercise of discretion. In the third category, which is public policy, there is no exercise of discretion. In the second category, party connected, where it is a question of natural justice, you must then consider the issue of prejudice, and there you may have a discretion, even if there's a technical violation. If the party who has raised it has really suffered no prejudice, you may have some residual discretion. So that is how our courts have understood it. So may has been restricted only to, the discretion in may has only been restricted to 2 or 3 heads. We have not gone the way of some other courts which were criticized and mentioned by Mr. Nariman, which say that even if an award is annulled at the seat, and despite 5.1e, you can still, in some sense, exceptionally sustain the enforcement. So we've not really gone down that way. You know, Yukosh came here and it did not come here. So this is still an open issue of annulled awards. I can give you one other example of so-called annulled awards, where the matter was pending in the Supreme Court, and George, you were on the other side, which was the Mauritius case, where we were trying to enforce the Mauritius Supreme Court award, but the Mauritius award, but the Supreme Court then set it aside, and that matter is pending in the Privy Council, and we did not then pursue our enforcement here. So that question is still open. So that is how I would respond, and obviously I would wait to be corrected by Professor Vandenberg as to the true interpretation of Article 5.1.
Thank you, sir. And speaking about the UCOs and the Mauritius, sir, so you had the opportunity to act on both sides now. So you would have seen it from both sides on that. And on that note, coming to Professor Albertian, on the same thing, to what extent should a domestic court defer to or respect the decision of the forum in which or under the law of which the award was made? Should a domestic court consider the judgment of such a forum annulling the award as having res judicata effect, or can it enforce an annulled award? How relevant are these principles for judicial committee? And what does under the law of which mean in this context? Also in the context when we were just speaking about international award being an award without international borders. Professor Vandenberg.
So, but what do you want me to address? Because I know two questions on my plate.
Your thoughts.
First, the question of May.
Yes.
Then the question of the enforcement of annulled awards, because that's slightly connected. Although I understand the Indian courts have taken, in my view, the correct approach that an award annulled in the country of origin is annulled and it's the end of the story. Because I think the Indian courts have only the discussion whether in cases of violation of natural justice, you can apply still residual discretion. And for the rest, it's up to the courts and leave the system intact. But may I point out for the question about May, with all due respect, Professor Banerji, you quote incompletely Article 5, because it says, and let me tell you, so if the full text of the introductory language reads recognition and enforcement of the of the award may be refused at the request of the party against whom it is invoked, only if that party furnishes the competent authority where the Christian enforcement is sought, prove that. So may only if are the operative words. Now, there are two interpretations. The first interpretation is uncontroversial about the meaning of the sentence. It means that may only if means that the grounds that follow are the only grounds that may be applied. And the enforcement court may not invent other grounds for refusal enforcement. So the exclusivity of the grounds. And everybody agrees on that. So and that's the natural meaning of the language in my view, may only if. The question, however, is, and let me, maybe the students will appreciate this example. So assume that I have undertaken the obligation to give everyone a room in this room or virtually a beer. The sentence then has the meaning, I may refuse to give you a beer only if you furnish me proof that you're under 18. Only if you furnish me proof. Now, but now comes the question, and that's the discussion. Does the introductory sentence also have a second meaning? In that the enforcement award has the discretion to grant enforcement of an award in the case where the respondent has furnished proof that one of the grounds for refusal enforcement is present. And indeed, the English text employs the word may and not shall. And it would suggest a discretionary power. But the word may should, in my view, not be read in isolation. The operative words are may only if, and not may alone. Thus, in the example I give you, it does not mean that I may still give you a beer if you are under 18. And the fact that 5.1 of the new convention does not have the second meaning of discretion is confirmed by the French text. And simply to recall you that the convention has 5 authentic texts. You see in Article 16, 2 of which are English and French. And it is no secret that in New York at the conference in 1958, the convention was negotiated both in French and in English. So they were the operative text. And if you look to the other texts, although called authentic, they are either a translation of the English text or for the French text or a combination of the two. Now, if you look to the French text, that is which is an equally authentic text, then you see that it reads, and now read it in French, la reconnaissance et l'exécution de la sentence ne seront refusées sur la requête de la partie contre laquelle est invoquée que si cette partie fournit l'autorité compétente, etc. Now, this French text clearly stands for the first meaning of the limitation of the number of grounds. Only the grounds that follow. But it cannot have even the second meaning of a discussion. In that case, it would have read quite differently in the French text. And I will save you the French text of how discretionary meaning would read. Now, in any event, if the drafts of the convention truly wish to have a discretionary power, so the second meaning of Article 5, residual discretionary power, they would have done it in a clear way, and they have not done it. And they know how to do it, because look, for example, to Article 6. There you have the adjournment provision, where an enforcement court may adjourn, and that is only if the award is pending for setting aside in the country of origin. And there the text makes clear that the enforcement court has a discretionary power to adjourn the enforcement proceedings, and I quote, may if it considered proper. And there's no words of only if. And it's also, what I tell you here is confirmed by the legislative history of the convention. And the draft committee had a may and shall, but you don't see any discussion. And there's nowhere to be seen in the legislative history of the convention that the draft is intended here a discretionary meaning of residual enforcement. George, the first question. Yeah, okay. Gourab, you have an answer?
So my question is, you say that there is no residual discretion to enforce, or
no, that I don't say. I say what I say is may is not a license to do anything, especially not to enforce another words. What I say is what you say about the residual, for the question about de minimis violations. I say yes, that is you have a latitude there. Because it should be, so I think you can interpret those grounds, but it's not on the basis of may, but in a different way. You can interpret those grounds as stating that you should not refuse enforcement in all cases. I can see that if you, and that's what your natural justice point, I think the Indian courts are right there, but I would not have based it on may. I would base it on the inherent powers of a court in interpreting a treaty.
Thank you.
Can I just come in? Mr. Nariman wants...
Just add one thing.
Yeah, he just had something to add.
May I just add one thing? That the sense in which the word may is used is a matter of some difficulty. But I would resolve it in this way. In my library behind me, I have Black's Law Dictionary. I have the Oxford English Dictionary. And in both, one of the subsidiary meanings of may includes must. You'd be surprised. Not with reference to shall, must. And anyway, if you look at clause 2 of Article 5, recognition and enforcement of an arbitral award may also be refused if the competent authority in the country where recognition and enforcement is sought finds that the subject matter of the difference is not capable of settlement by arbitration under the law of that country. Now, this certainly is a must. This can't be just may or may not. Because if the competent authority finds that the subject matter of the difference is not capable of settlement by arbitration under the law of that country, should enforcement of the arbitral award be granted? How can that be? That's a contradiction in terms. I don't want to venture into the French meaning of it, because ever since I was in college in the first year arts class, and my professor said, where did you go to school? And I said, Bishop Cotton School, Simla. And he said, but poor boy, why did he go so far to learn so little? And that was in a French class where he was teaching us French. So my submission would be that the word may, which is in the Article 5.1, has a reflection on the same word may in 5.2, where it's quite clear that where the competent authority finds that the subject matter of difference is not capable of settlement by arbitration, it must refuse. It can't be that it may not refuse. I mean, that sounds a contradiction in terms. Therefore, and that is supported by dictionaries. Of course, you can argue from anything from a dictionary. And ultimately, all that it means is what your highest court will ultimately rule and say. I'll give you a little quote. I've got a quote here of a Scottish judge, very old judge, who has said, Judge Sands, and he says, the House of Lords, and for House of Lords, put your own Supreme Court, if you like, or the Supreme Court of England and Wales, or the Supreme Court of Netherlands, is an infallible interpreter of the law. A batsman who has been struck on the shoulder by a ball protested against the ruling of LBW, but the wicketkeeper met his protest by the remark, if you don't, it doesn't matter if the ball hit your head. If the umpire says you're out, you're out. Accordingly, if the House of Lords says this is the proper interpretation, it is the proper interpretation. So I'm afraid we have come back to the square one. Whatever your Supreme Court says, the interpretation is the proper interpretation. But I would respectfully submit that there is much substance in what Albert Jan has put, namely that this word cannot have any scope for discretion at all. That there is a possibility of taking that view also.
All right. Okay, if I may, no pun intended. In the French text, I know, Fali, you were not you were very successful in your life, but not in the French class that much. I understand. But if you look in the French text, the difference in text between the French text for 5.1 and 5.2, it's quite remarkable. They use different words for there, and I will not quote them, otherwise everybody gets confused. But look at those, the difference between the two. That's quite remarkable. So George, you had the other question about the judgment. Is that still, because I got compound questions.
Could I just ask you one question, just to follow up on what you said, Professor van den Berg? There are, of course, eminent commentators on the New York Convention, such as Professor Gaillard and Jan Paulsen, who advocate a different approach. And I think, well, of course, one approach is the textual approach, which you've outlined. I think they adopt maybe what is called as a delocalized approach, or in some senses, even a pragmatic approach. Because what the pragmatic approach seems to recognize is that there are certain jurisdictions across the world where the courts may not have the standards of judicial independence that you may expect from a court. Especially when it comes to cases involving the government. They may not be in favor of deciding against the government, or they could, for instance, decide on purely local standards. So for example, if a local court decides to set aside an arbitral award on the basis that the arbitration agreement has not been properly stamped, I mean, should that application of national standards bind every other court across the world? Or should courts nevertheless have the ability to review for itself whether the annulment meets international standards, and at that basis take an independent decision on whether or not to enforce the arbitral award?
Professors Gaillard and Paulsen have my sympathy, but I must tell them what they are advocating is basically the European Convention of 1961. If you look to the European Convention of 1961, maybe not known to many of you, but look it up, there you will see that the treaty provides for specific provisions for the enforcement under the New York Convention of annulled awards. So you need a treaty basis for doing that, for a residual application for enforcing awards that have annulled in the country of origin. And the European Convention of 1961 is to the effect that if the award has been set aside on grounds other than specified in the European Convention, then you may still enforce the award. So that's specifically in the European Convention. And what is now interesting at this point, and that proves my story, that you cannot read the New York Convention this way. The European Convention was drafted and concluded 3 years after the New York Convention. And most of the negotiators of the European Convention of 1961 were the same persons as those of the New York Convention. So they knew exactly what they were doing. So if they had wanted in the New York Convention a system for enforcement of annulled awards, they would have done it. And they did it in the European Convention of 1961. So historically, it's also it's on my side, but they get a little bit carried away, I assume, with my sympathy, because I really want to promote international arbitration. But if you do it, change the convention, as I proposed in 2008. But that is not liked by my friend Gaillard.
The other approach could be that the New York Convention is an international treaty, and one of the guides of interpretation could be subsequent state practice. So if subsequent state practice has probably consistently taken the view that states have this residuary discretion, would that in a sense influence the proper interpretation of Article 5?
Yeah, sure, but arguably. But how many states do it? Courts in how many states do it? There are a handful. It is maybe you have US. It is the US. You see, English courts have to make some noises. The Dutch courts have decided in this way, although on different theory, not on the May's theory, and a few other countries. That's it. But other states are very clear about this. Other courts in other states. This is simply the court. The New York Convention says, if the award has been set aside, then we have to refuse enforcement. That's what we do. And if I may, I'm sorry, unless because now I'm a hobby horse, because about the judgment theory, because that's what you refer to, I think, George or Gourab. So should we enforce the judgment setting aside? But that's not the question. Where in the New York Convention is it said that you have to recognize the judgment setting aside? What the New York Convention requires the respondent to do is to prove three things: that the award has been set aside, 1, by a competent court, 2, and 3, in the country of origin. Once you have proven that, that's all. Why do you need then to add a layer of complexity by enforcing a judgment? And God help us, which legal basis do we have for enforcement of foreign judgments? In very many countries it's different. And nowhere is that to be seen, this legal basis for enforcement of judgments, in the New York Convention. They complicate the convention unnecessarily, in my view.
Thank you, Professor Vandenberg. I think that was a fantastic debate. I think Professor F.A. Mann would be very pleased to hear about the territorial approach. Thank you for that. So from one controversial topic to another, one of the current topics or the current controversies in relation to the application of the New York Convention is whether the interim orders of arbitral tribunals, or for that matter, emergency decisions or decisions of emergency arbitrators could be enforced under the New York Convention. Niuscha, could I request you to provide us your views on that topic?
With pleasure, yes. First of all, what are we talking about? We're talking about emergency arbitrators' decisions, which may be decided in the form of an order or an award. Now, I remember very well ICCA 2012 in Singapore, where emergency arbitrator proceedings were a really hot topic, and it was novel. 8 years later, we have 30 arbitral institution rules that provide for emergency arbitrator proceedings. So it has evolved exponentially. And out of these 30, I can provide a list if someone wants. I made a little research. Out of these 30, there are 80 institutional rules that provide that the emergency arbitrator may decide, bad use of word, shall decide by way of an order, and 16 institutional rules provide a choice, either in the form of an order or in the form of an award. So in terms of the New York Convention, of course, this raises a number of questions, and I don't think I have the answers to them, but they have been explored as well at length in various task forces, and I have been privileged to be a member of the ICC task force on the emergency arbitral proceedings, which produced a report, and it's quite, it's one of, I didn't draft it, I was just a member and I contributed to it, but I think it's one of the best ICC reports of the task force, I have to say, because it gives a very good overview and quite a good guidance, although the ICC is very clear that it doesn't give guidance or advice for how to deal with emergency arbitral proceedings. Anyway, so what comes as a question, the first one is whether the emergency arbitrator is an arbitrator or is it an adjudicator? And here the New York Convention doesn't help us so much because in Article 1.2, where the arbitral award is kind of defined, it says the term arbitral awards shall include not only awards made by arbitrators appointed for each case, but also those made by permanent arbitral bodies to which the parties have submitted. So the emergency arbitrator is actually somewhere in a limbo of whether it is an arbitrator or not, because it is preceding the establishment of the tribunal. The next question is, what is the nature of the emergency arbitral decision? And is it final or is it an interim decision? Is it an interim decision because it only deals with an interim preliminary matter, or is it a final decision which in itself, even if interim, is still separate, discrete, independent, severable? These 4 words are from a quote from a US court decision where an interim award was enforced. And so we have here quite interesting also as a background, the point that back in 2018, the Queen Mary and White and Case International Arbitration Survey showed that about 61% of the respondents indicated that increased efficiency, including through technology, would have the most significant impact on the future evolution of international arbitration. They were quite right if we look at us today about technology. But still also greater certainty and enforceability of awards was selected as the second most likely factor to have a significant impact on international arbitration. And it was only actually a couple of years earlier, in 2015, in that same survey of Queen Mary University and Whiting case, that the enforceability of the emergency arbitrator's decision was at stake. And back then, 79% of the respondents considered the concerns about enforceability of the emergency arbitrator decisions to be the most important factor affecting the choice whether you would actually go to a state court for an interim relief or for an emergency arbitrator. Now, the task force that I referred to published the report last year. And in that task force, 80 ICC emergency arbitrator cases were analyzed. And of these 80, the compliance rate has been enormously high. So first of all, only 23 cases of those 80 cases actually did grant the interim relief. And out of those 23 cases, only 3 cases had compliance issues. Otherwise, it's a very high compliance. So one question that we can put to us is it really a very hot topic to talk about the enforceability of emergency arbitrator decisions if they're complied with anyway? But it is, and we can see that in the change of law in several jurisdictions already. We have at the forefront Hong Kong, Singapore, and New Zealand, which have provisions in their amended arbitration acts that provide for the enforcement of decisions by the emergency arbitrator, whether by order or rendered by an award. And it is quite interesting that, to get back to this first question, is an emergency arbitrator really an arbitrator, that at least Singapore and New Zealand took that route. So they put into the definition of what is an arbitral tribunal also the emergency arbitrator. They included the emergency arbitrator into the definition of the arbitral tribunal. That's a very neat and nice shortcut in order to avoid any knock-on effects about what are the powers of the emergency arbitrator, what is the consequence of that decision, can it be enforced, because then it is on an equal footing. Now, in countries that have opted for the adoption of Article 17H and 17I of the UNCCI model law, those countries have been, there is at least a tendency that they would consider that emergency arbitrator decisions are enforceable as well. Why? Because 17H and 17I of the UNCCI model law provide for the enforcement of interim measures. It doesn't say interim measures by emergency arbitrators, but the thinking is that if interim measures by tribunals are enforceable, then also interim measures granted by an emergency arbitrator should be enforceable. Belgium, my other home country or jurisdiction, is actually one of those who has amended its law in 2013 and has taken over exactly that novelty. In fact, there are about 30 UNCCI model law countries that have taken over 17H and 17I out of the 80 or odd UNCCI model law countries. And so this is one way to look at it. The other one is also pragmatic view, is to look at the decision, the court decisions of other countries. And we have here, for example, in the US, a court decision where it did in fact also enforce the interim measures award. Then we have a Cairo Court of Appeal decision, same thing, where the interim measures were actually also enforced, but these two were by the tribunal. So again, not yet by the emergency arbitrator. But I think something can be derived of this, that there is definitely a trend or an upcoming trend, not there yet, we are at the very beginning, to enforce interim measures, whether they are ordered by a way of an order or by an award. And a very interesting case, and that reminded me a little bit of what Pramod just said about jurisdictions where maybe you, I don't know, I put it very bluntly, where maybe the courts would side with its own country, is this very interesting emergency arbitrator case, which was rendered under the SCC rules, the Swedish Chamber of Commerce rules, in an investment arbitration against Ukraine. And the SCC rules do not provide for any form of the decision, it only says decision. The arbitrator decided that the decision should go by way of an award. It ended up before the enforcement court in Ukraine, which immediately, without even discussing, addressing an emergency arbitrator, is it a tribunal, yes, no, enforced it. And it enforced it and treated it like an award under the New York Convention. That decision was overturned by the Court of Appeal in Kiev. And then in 2016, going further up to the Ukrainian Supreme Court, the Ukrainian Supreme Court quashed the Court of Appeal decision and remanded it back to that court, emphasizing that that court had not analyzed the enforcement under the New York Convention and that it should, in other words, do so. So that case is still pending to my knowledge, but we can see, I mean, it's quite a remarkable case because in an investment arbitration, because it is actually against its own country. The court had decided, the first one, the lower court and the Supreme Court, basically against its own country and in favor of the enforcement of an emergency arbitrator award. A lot of matters are still unsettled, but I am foreseeing a good number of cases coming up despite the high compliance rate, because a case like this Ukrainian case actually encourages, I think, other parties as well to go forward. So it's not in the New York Convention, but it has been maybe dealt with then better in national laws.
Thank you very much, Niuscha. And I think a very interesting point that has been made is that at the time when the New York Convention was being negotiated and was finally signed in 1958, arbitration statutes across most parts of the world did not confer a power on arbitrators to make interim orders. That was really something which was brought about primarily by the ancestral model law from 1985 onwards, which became the legislative template for arbitration legislations across the world. So in that sense, maybe this was not something which was envisaged by the drafters of the New York Convention. In the same way, for instance, as why investment treaty awards should not really be subject to the enforcement regime of the New York Convention. The first investment treaty was in 1959 between Pakistan and Germany. It did not provide for investor-state dispute settlement. It provided for state-to-state dispute settlement. So the question that I have for you, Professor Berg, is the New York Convention now too old? Is the time now ripe to reform it? Is it now showing its age, and does it have to be refreshed or does it have to be replaced? And I direct this question to you because 12 years back, when there was huge celebrations all across the world for celebrating 50 years of the New York Convention, you were hard at work in preparing a new model convention to replace the New York Convention. Could you tell us what you hope to achieve with that? And do you still take the view that the New York Convention needs to be tinkered with, if not replaced in its entirety?
Let me preface this one, what I did in 2008. There I was invited to give a keynote speech on 50 years New York Convention. And as all of you who have to give a speech wonder, what way should I present my speech? So at that time I thought, well, maybe what I do is I place myself back in time and think about what if I had been a delegate in 1958, what would I have now considered in 2008? So that was actually figuratively my speech. But then it was taken literally as a proposal for amending the New York Convention, which on reflex I thought was a good idea actually. But it was not intended at all at the time. It was simply a speech and to make it, to put it in some format. But my friend Emmanuel Gaillard, he jumped on it. No need, no urgency, and no future. Well, he had 3 no's immediately, and I was a bit surprised that he would say this, because he comes from a country which does not apply the convention in the first place. The French courts don't like the New York Convention. They only know one provision in the convention. It's Article 7, that's how to get out of the convention. That is, it's the more favorable right provision. If your own law is believed to be better for the enforcement of foreign awards, you use that. So they know that, and they go that far even to the Supreme Court, but to telling the courts if they don't apply it on their own motion, they must apply it on their own motion. So they're very proud of their own law. That is the law that sanctions the deplorables of international awards, which have been set aside the country of origin, but they can be resuscitated in France. That's that law that enables that. That's not the New York Convention theory. That's the French law theory. So, and he made then the point that there was no need for changing it. I thought if any country is an example, it is France who would advocate we have to revise the convention. And now to come back to your convention, is the convention in need of change? Having written the speech and having seen the reaction I received, I think yes. Maybe not that quickly, but it is a project we should start thinking about. The cracks are showing. If you look, and I give you a couple of examples. If you look to Article 1, as also pointed out by Fali Nariman, it is strange that the same award is subject to 2 different regimes for enforcement. One is the New York Convention if it is abroad, and one is the local law if it is in the country, enforcement in the country where made. That's very, very strange for an award in international arbitration for the same award. Then if you look to Article 2, it has what I mentioned holes in it. The one difficulty is Article 2, paragraph 2. What is the definition of an arbitration agreement in writing? Now, UNCC tried to rescue this by an interpretation in 2006 in the guiding notes by saying, well, you have to read the word include as include but not limited to. However, that is again not borne out by the text in the other equally authentic texts. Plus, it's not borne out by what you see in the drafting history. The drafting history makes clear that a tacit acceptance is excluded. There was voted in 1958 for a tacit acceptance that it should be included, and specifically the delegates in New York in 1958 voted it down. So how you then can reintroduce it, it's for me a difficult point. Article 2 has another point, is this it does not define even which arbitral awards or arbitration agreements, fall under it. There's no field of application is being described. Article 3 in itself is about the commencement of the agreement of the enforcement of awards provisions. There's also a troublesome provision, because it is now being interpreted as a non-discrimination provision with domestic awards. Lots of confusion, and that also needs to be revised. 4 has then issues about authentication, because the award needs to be authenticated according to the text. So it means that the notary should be present in the extremis, should be present when the arbitrator is signing the award. So there are also a host of issues. In Article 5, we have just seen about the problem about May, that is misunderstood in my view by a number of courts, and you get the issue of the annulled awards. And I was very happy to hear what Fali Nariman said in the beginning, in the opening. It needs to be interpreted in the way that you have international standards. That's indeed the case. I agree with that. that if that could be changed. But the way to do that is amend the convention, like the drafters of the New York Convention did in 1961 with the European Convention. Now, and then for those who have problems falling asleep, please do read Article 7, paragraph 1. And if you have read after 10 times, I assure you fall asleep, and but you still not understood it. But I will not go further with my case.
Thank you, Professor Vandenberg. I think the article of Professor Gaia that you're referring to was titled "The Urgency of Not Revising the New York Convention." But you know, given the fact that the creation of the Multilateral Investment Court is now firmly on the agenda of UNCCC Working Group 3, there could be, in due course, a real urgency in revising the New York Convention to integrate it fully with the Multilateral Investment Code, assuming, of course, that that's the consensus that emerges during the discussions of the working group. So on that note, I'll hand over to George, who will raise the theme of the last theme for today, which is on ISDS and the New York Convention, and then we'll move to the audience questions. George, over to you.
I mean, a simple question to you, Professor Vandenberg. The first thing, is an ISDS award commercial and can it be enforced under the New York Convention? I'll come to the second part of it in the Indian context to Mr. Banerji later, but if you could have your thoughts on this first before we go ahead.
Yeah, I think the question is, if a country has made the commercial reservation, can it then be enforced in the New York Convention? Or is your question under the future MIC as contemplated by the European Commission, whether that is enforceable?
Professor, the first question is an ISDS award commercial in the current context? Can it be enforced under the New York Convention?
All right. So if you assume now that the country has made use of the second reservation of Article 1, paragraph 3 of the New York Convention, and I read it to you, a state, when it accedes to the convention, may also declare that it will apply the convention only to differences arising out of legal relationships, whether contractual or not, which are considered as commercial under the law of the state making such declaration. Now, in practice, 1/3 of the contracting states have made that reservation, and if then an award is presented to a country that has made the reservation, the question arises whether that award is commercial. And here you have to make a distinction, in my view, between, on the one hand, investment contracts and investment protection. Investment contracts are contracts concluded with an investor and a state, an whole state, for example, for building an hotel. And there can be all kinds of clauses in it. And basically, in the most countries, I understand it, that such a contract, even if it concerns investment, is commercial. So there is not the issue. If it has also an arbitration clause in it and an award is being rendered under such an investment contract. The real issue is with what is called investment protection, bilateral investment treaties or multilateral investment treaties. Those treaties contain provisions on the protection of investment. And then the question comes, is expropriation, for example, which is, they may not expropriate under certain, unless certain conditions are fulfilled, is that commercial? Making the investment in itself may still be commercial, still building the hotel. But what about the situation that the host state expropriates the hotel? Is that a commercial act? And think about your own country. If your part of your land is being expropriated because the state wants to build a road to your on that land, that expropriation, is that a commercial act by the Indian authorities, or is it something else? Is it an administrative law or a public law act? And if that's the case, is then that act, would that be then commercial under Indian law in terms of Articles 1, paragraph 3 of the New York Convention? And that is the reason why, if you look at a number of bilateral treaties or multilateral treaties in the field of investment protection, you see that they have a specific provision. An example is Article 26, paragraph 5 under B of the European Charter Treaty, that provides, and I have the text here, is it under B? Any arbitration under this article, it is Article 26 of the European Charter Treaty, shall, at the request of any party to dispute, be held in a state that is party to the New York Convention. Claims submitted to arbitration thereunder shall be considered to arise out of a commercial relationship or transaction for the purpose of Article 1 of the Convention. So here you have a specific provision in these treaties, because the drafters are aware this is a serious issue. And indeed, it is a serious issue, because if you have not such a provision in the BIT or multilateral treaty, is then indeed the matter caught by the reservation of Article 1, paragraph 3 of the New York Convention. And even if, and that's even the worrying part of it, even if there is such a provision in the applicable BIT or multilateral investment treaty, then still questions may arise, I understand, from several cases now around the world.
Professor Vandenberg, just if I could have it as a follow-up on this, I mean, on the current treaties we had, the future, the multilateral court, right now under working group 3, the discussions are certain countries want to have a judgment or award of the multilateral court to be enforceable only under the New York Convention. So would it be possible to export provisions of the New York Convention to the multilateral court, especially when each country, talking about the commercial reservation, what is commercial would be as per laws of each country, and a multilateral court could have a vast number of countries. How do we balance this? What are your thoughts on that?
Okay, but you can try, I would say try to do it as they did with the Energy Charter Treaty and a number of other treaties, to do it in that way. So you simply declare that it's commercial. Whether it will work in practice, that's another question. But I think with the MIC, the real biggest issue, there are two biggest issues in my view, is whether is there an arbitration agreement between the parties, and the other one is, if I look to the present proposals by the European Commission, that is that the appointment of arbitrators are all in one hand, the states. And so and that may raise issues of the investors, whether there is an equal opportunity for appointment of arbitrators, or indirectly and the type of arbitrators that are not only designated by the states.
I mean, the debate is still on whether to have investors also participate in that. I mean, but I think that's a long way off. Now to Mr. Gourab Banerji. Sir, on the Indian context, you very well know about the judgments in the Vodafone case, Pothan case, which reiterated Vodafone. But if you look at paragraph 45 of the Pothan case, despite reiterating Vodafone, the court also went on to say, when it did not stay the anti-arbitration injunction, the court also went on to say that we should respect our treaty obligations. Wouldn't enforcement of awards be an extension of respecting the treaty obligation to arbitrate? The first point. And the second thing is, so far we haven't been faced with the enforcement of an award. The only enforcement proceeding, to my knowledge, which came to India was UCO's. A Bangladeshi related case had come, but I mean, even before the hearing, it was withdrawn. In the new model BIT, India has, however, clarified it to say that any award under the any award under the treaty would be treated as a commercial award under the New York Convention. So that's taken care of. But what about awards? We've got about 30 plus pending cases under the old treaties. We have just had a few awards which have gone against us. Nothing has come for enforcement to the Indian courts as yet. And also, like Professor Vandenberg had mentioned, what is commercial under the laws of the state? What is commercial under India? So do you think that investment treaty arbitrations awards can be covered in the New York Convention in India? So.
You asked me a very difficult question here. May I reserve that to the next webinar? Because we need more clarity. It has to still to crystallize both in the courts and also in thinking. It's a very difficult issue. I give the contours of the question because if you have it in a treaty, can you then reason a contrario? If you have not it in a treaty, then it's caught by Article 1.3. It's not easy questions.
George, can I also reserve, looking at the time and the fact that we are already running over time, I think that's a very difficult issue. And I prima facie agree with Justice Manmohan's analysis in paragraph 91, that as long as we do have a commercial reservation and without actually putting it in our domestic law by, say, amending the Commercial Courts Act or having some domestic legislation, I'm not even sure that your model BIT will be able to help you out and sort of fit it in once you have the commercial reservation, which is reflected in section 44. So if the court doesn't have the jurisdiction, it doesn't have the jurisdiction. You can't put it in by some other method. I actually agree with the judgment in Vodafone in paragraph 91, and I'll just read it out, looking at the paucity of time. Investment arbitration disputes are fundamentally different from commercial disputes, as the cause of action, whether contractual or not, is grounded in state guarantees and assurances and are not commercial in nature. Roots of investment arbitration are public international law, obligations of state, and administrative law. And if that understanding is correct and you have a commercial reservation, then you'll have to do a lot more to get back into the New York Convention if an award is brought.
George, could I just step in for a moment?
Yes, Prabha, I was just going to ask you.
Let me kind of,
not agree.
As a moderator and just maybe play the role of a devil's advocate. I think there are two aspects to it. The first aspect, and Professor Vandenberg, I'm playing the role of a devil's advocate. And please forgive me if I'm seen as disagreeing with you. I think there are probably two distinct points in time. The first is the time at when an investment is formed, and when a relationship is formed between the investor and the state in which the investment is made. And if that relationship can be classified as commercial, I think that's what is relevant from the purpose of bilateral investment treaties. The subsequent action which you referred to, which could be the act of expropriation, or it could be a failure to grant fair and equitable treatment, that is really an alleged breach of the investment treaty, which does not detract from the fact that the original relationship between the investor and the state in which the investment was made was commercial. And therefore, from that point of view, it may be possible to say that all these investment disputes are essentially commercial in character. Gourab, as far as the point that you mentioned, I mean, I think there is a distinction again between the quality of the legal relationship between the parties, which obviously is commercial, and the Indian courts have taken a broad approach to the meaning of commercial, and the subject matter of the dispute, which is a different matter. The subject matter of the arbitration may not be arbitrable, for instance, because it's an act of state. An act of expropriation could be an act of state. It may not be justiciable in that sense before a domestic court, but that's a different question. The award, nevertheless, is commercial, but whether it's arbitrable and whether, for example, the court could review it on the grounds of arbitrability or non-arbitrability at the enforcement stage is a slightly different issue. So I think, as Professor Vandenberg said, many of these issues will probably have to be crystallized in future decisions that the Indian courts will probably have to address, as I'm sure will be the case with courts across the world as well.
I think the answer is we agree to disagree on this issue as to whether a New York Convention applies to an investment treaty award, and I'm sure we'll have some wisdom, not from a single judge, but maybe from the Supreme Court. So let's see where it goes.
Let's see if this reaches the Supreme Court after all.
Thank you everyone for your enriching views. The audience has been extremely active. We've got 27 questions so far, which I'm sure will take another couple of hours, which we don't have the luxury for. Could I just mention this, that there have been requests from the audience for references to the case law and the articles, and we will be uploading it on the MCIA website. Could I just pose a couple of questions, and George will also pose a couple of questions on the ISDS side. Professor Vandenberg, one of the questions that have been asked is, are anti-arbitration injunctions contrary to the underlying spirit and purpose of the New York Convention?
May I refer that question to my esteemed partner, Niuscha Bassiri? She knows that everything about anti-suit injunctions.
Over to you, Niuscha.
Oh my God. Yeah, thank you.
Or you want me to answer it?
No, no, I just know I have a beautiful quote from Stefan Schwebel, or Stefan Schwebel. It's considered as one of the gravest problems of contemporary international commercial arbitration. That's what he considered as anti-arbitration injunctions. Now, I think that is the same that you were referring to, anti-suit injunction. Of course, I know the one is from the court. So the anti-arbitration injunction is a problem, I think. But I think it's also a problem like who has the power, which court has the power to actually issue anti-arbitration, anti-suit injunctions. But having said that, I think it's very, very difficult to not obey to an anti-arbitration injunction that has been issued by a court at the seat of the arbitration against the arbitral tribunal. Now, the New York Convention, Abadian, doesn't say anything about it. It doesn't forbid it either. It's not that it is not permitted, whether it's against the spirit. Well, I leave that part of the question to you.
All right, now it is the West Tankers case, basically.
Yes.
Talking about West Tankers. Remember, for those, for the younger viewers will not know what the case is, but it's a famous case in England that was referred to the European Court of Justice. And the question is whether the English courts had issued a cross-border injunction in relation to court proceedings in Italy, and they should stop because the place of arbitration is in London. And then the European Court of Justice says, well, in the context of European law, you may not issue cross-border injunctions. So it was interesting to read, because after Brexit, I read all kind of jubilant articles by solicitors and barristers in London that now, finally we can have cross-border injunctions again in England, because we no longer part of, at least it takes a while, but no longer a part of, fall under the European Court of Justice. But the question whether it is compatible with the New York Convention, I have my question marks myself, because in the context of Article 2, Paragraph 3, these questions of the validity of the arbitration agreement are being addressed by the court before which it is raised. And I think it's somewhat curious, if I may use that word, that courts in other countries can tell a court in a certain country how to interpret and apply Article 2, Paragraph 3 in a case before them. So basically what's happening there. So it is cross-border injunction is typically an invention by the common law countries, especially in England and New Wales. But in other countries, it is not so much, at least, either does it exist or not much practiced. And New York Convention, that raises question marks.
Thank you.
May I be permitted to say something?
Of course.
So my understanding is that obviously Professor Vandenberg is right that it's an invention of common law countries, and we are a common law country. And I would think that there is no problem in issuing an anti-arbitration injunction in a very rare circumstance if the grounds under Article 2.3 are made out, perhaps. That could be a very limited possibility. There is a very recent Calcutta High Court judgment of a single judge, which seems to suggest that you can issue such an injunction, but he didn't do it. So just as a matter of interest, it's traveling up.
That's an anti-arbitration injunction, but I was thinking about anti-suit injunction in the context of the New York Convention. So the English courts telling the Italian courts, of the parties proceeding in Italian courts, you may not proceed in the Italian courts.
Yeah, anti-suit injunctions are also something that are contemplated in India, but very, very rare. I think that Modi Entertainment is the judgment, which World Sport Group. But you're right. I mean, it's really overreaching yourself, telling another court not to interfere. But they get around it by saying, "I'm not telling the court. I'm telling the party not to go."
Yeah, exactly.
That's the.
I can tell you, the courts take that pretty personal.
Thankfully, the Italian torpedo is now quite rare. So some of these debates as far as anti-suit injunctions are also becoming progressively less frequent. The next question that has been posed is it again consistent with the objects and purpose of the New York Convention to enforce an arbitration agreement against a third party? Under what circumstances can this be done? And does this render an arbitral award against a third party vulnerable to challenge? to any of the participants, to panelists who wish to answer.
Arbitration agreements questions go to Niuscha.
Niuscha, over to you. And I think the reason why it's particularly topical is because the United States Supreme Court recently issued a two months back in the GE Power case, where it enforced an arbitration agreement against a non-signatory on the basis of the principle of equitable estoppel.
Yes, so it goes back, I think, to the applicable domestic law, to which extent I think non-signatories can become part of the arbitration. But if under the New York Convention, the award specifying only those, so it is, so if it is, if there is an award and there is already there are the two parties named, or the parties named, and I find it a bit dubious to enforce it against a party that is not named. But of course, it goes back again to the control of the domestic courts on the ultimate question of the arbitration agreement, the jurisdiction of the tribunal. So if there is a full de novo review, as is the case, I think, in the United States. So then I think it can indeed happen that the court there would actually go beyond of what had been submitted to the tribunal, or even assess what has been submitted to the tribunal, and might come to a different decision.
Thank you, Niuscha. I think we probably have time for one or two last questions. George, over to you.
Thank you, Pramod. Again, a question to anyone on the panel who wants to take it. Would failure to comply with the obligations under New York Convention raise a possibility of an investment treaty claim? Not raise, can it amount to an investment treaty claim rather? I mean, we've had it already in.
Let me say, I don't answer the question because that question is pending before me. So I'm out. Gourab, you can answer.
Gourab, yes, if you're not conflicted in one way or the other, I'll be glad to answer.
So I think we've already had that White Australia sort of situation where, because the award was not being enforced in India for a long time, there was a treaty dispute. You had the Saipem Bangladesh situation as well. So, I mean, there's no obvious answer. It'll have to be seen in the facts, in the particular, in the nature of the treaty, the nature of the dispute. So, I mean, there's no specific answer. But yes, in theory, it can be done. I think Pramod will have something more to say on this.
I actually had a question for you, Gourab, and hopefully we can hear from Mr. Nariman as well, because he's spoken about white industries at the Herbert Smith lecture in Singapore a few years back. The question that I had for you, Gourab, is that let's assume that in a hypothetical case, the Indian Supreme Court had decided that the White Industries Award was contrary to the public policy of India, and it refused to enforce the arbitral award, by which time the investor had already received a decision in its favor in the BIT proceedings. What would happen then? Because the failure on the part of India was the delay in enforcement of the award. But at the end of the process, let's say that the Indian courts ultimately decided that the award was not enforceable as a matter of Indian law. What would happen then?
So interestingly, you know, of course, that White Australia was listed along with Balco, and it was withdrawn. It was the second matter in the list before Balco was decided. So, and you know which way Balco went. But yes, I mean, hypothetically, this would be very interesting that India was in breach of its obligation to decide expeditiously. So one could then argue that regardless of the fact that we refuse to enforce, or the Supreme Court refused to enforce, in any event, you have breached your treaty obligation by not deciding one way or the other within the necessary time. I don't think you can have an application for restitution. That might be very difficult to manage.
The investor wouldn't complain because it would probably be entitled to enforce an award, despite the Indian courts then saying that it would not be enforceable as a matter of Indian law. And these are probably controversies of the white industry's decision. And hopefully, Mr. Nariman will have a few things to say in his concluding remarks.
I think white industries will require one more webinar. So I think I'll defer to that because I was involved in some way. So I'll keep quiet.
Okay.
Thank you. Thank you, sir. Thank you. Thank you to everyone on the panel. I think it was a very, very interesting discussion and we could have gone on. There's now 30 plus questions and we are really running short of time. We'll try and revert to the questions if we can, but all things have to come to an end. I think it's time to conclude the session, and can I request Mr. Nariman to deliver the concluding remarks?
Out of time, and may I just say one or two things. Listening to all this discussion, I've just thought of a question to ask myself, that in the years ahead, can the New York Convention hope to achieve a greater certainty of concepts and approaches to foreign awards, their enforcement and non-enforcement? And I'm very doubtful whether it can. The great Peter Sanders, acknowledged father of the New York Convention, had consistently reminded us that the New York Convention was drafted in an imperfect world. And if I may add, an imperfect world of sovereign nation states. After more than 62 years, and with 164 ratifications, it still remains an imperfect world of sovereign states. And state sovereignty is a major barrier to the development of any universal rule of law. Besides, I don't think we should expect too much from an international convention. It was deliberately fashioned so as to facilitate an easy application of its provisions to various and different and differing legal systems around the globe. I ask you all to recall one event, and if you don't remember or don't know about it, I ask you to note one very important fact, that after the conference in New York ended in June 1958, there was a brief statement that was issued as to what the draft provisions hoped to achieve. Only a brief statement. And this is what the brief statement read as follows: worldwide simple enforcement of foreign arbitral awards. That's all. Worldwide simple enforcement of foreign arbitral awards. And the simplest way for enforcement of foreign awards is working through and taking the assistance of national courts in the contracting states. Those who expect more will be disappointed. That's all. Thank you all for listening to this 2-hour discussion.
Thank you. Thank you.
Thank you.
Thank you to all the panelists. And I think on that note, we will close the session. Thank you also to the audience for listening in. I'm sorry we overshot the time by 13 minutes, but the discussion was so engaging that we just couldn't help it. Thank you for your patience on a Saturday. And thank you once again to the wonderful panelists that we had today. Thank you once again.
Thank you.
Thank you, Fali. It was great to see you again.
Thank
you. George, Gourab, and Pramod, and Niuscha, thank you so much.
Thank you.